For over 2,000 years, philosophers have debated the so-called irresistible force paradox, usually formulated as what happens when an unstoppable force meets an immovable object. The world got one answer to the question on 26th of March last year when a Singaporean-flagged boxship hit the Francis Scott Key Bridge that spanned Baltimore harbour in the US. Both came off badly. The vessel was inevitably damaged, the bridge collapsed, and 6 people from a maintenance crew working on the bridge at the time were killed. Within days, the owners and managers of Dali filed for limitation of liability. If their suit is successful, Grace Ocean, Synergy Marine and their insurers will pay out no more than $44 million. I'm David Osler. I'm the insurance and law editor at Lloyd's List, and in this edition of the podcast, we unpack what happens next, especially for the benefit of those on this side of the pond who will likely be unfamiliar with the way things work in America. Lloyd's List is a publication for ship owners and marine insurers and obviously takes a pro-shipping editorial stance. Limitation of liability has been around for well over 2 centuries. A cap on the risks involved in a maritime venture is essential for the smooth flow of world trade. But it doesn't take much empathy to recognise that the people of Baltimore will be furious at what happened. Any of us would be if something similar occurred where we live. From their perspective, the owner's bid to limit liability to a relatively lowly sum will look like an attempt to shuck off responsibility for the disaster. There are also vast implications for the marine insurance industry, much of which is based in London and is a bread and butter area of coverage for Lloyd's List. As most listeners won't need telling, marine liability is largely insured through the international group of P&I clubs. The IG operates on an ingenious system of retentions, pooling, captive insurers and reinsurance, allowing it to offer cover in excess of $2 billion. That level of payout was until now thought to be bulletproof. But in the face of what is shaping up to be the worst marine loss of all time, that assumption will be put to a stern test. If the application fails, the entire mechanism will come under strain. We have 3 guests on the podcast this week. Joanna Byron is a qualified lawyer who now works at the Houston office of marine broker Lockton. We will also hear from James Mercante, head of Admiralty and Marine Insurance at New York law firm Gallo Vitucci Clark. But let's start with a perspective from outside of shipping. Local politician Mark Adelson sits in the Maryland State Legislature, representing the district that includes the Port of Baltimore and one end of the bridge. Mark tells us what it is like to get a phone call from the boss at 3:30 in the morning, informing him that a disaster has quite literally struck. He also outlines the economic impact of the bridge collapse on the city and its reasoned case for compensation.
You know, we were about 2 weeks out from the end of the legislative session. I'll never forget, we were in the midst of deep budget negotiations, and I got a phone call at 3:30 in the morning from the governor's chief legislative officer. And, it's one of those things where when you're an elected official and you get a phone call in the middle of the night, it's never a good thing. And I was just in total shock as he described to me what had happened. Like everybody else, the first thing I did was sort of hop on social media and see that video, from the individual that is just absolutely jarring. And it took me a few minutes to appreciate what was happening, and then had to shower, put on a suit, and get over to the State House and start working on what we were gonna try to do. So, I think at the time it was really a mix of shock. Most people presumed that the loss of life would be far more extensive given how heavily utilized that bridge is. Thank God for the quick thinking of the guys who were working on the bridge and the emergency folks in the vicinity for shutting down the bridge so quickly. 6 lives lost is a horrific tragedy. It could have been way worse. So I think we were extremely relieved that that was the extent of the loss of life. And obviously that was the first focus, was to try to save anybody that could be saved, and then, recover the bodies for their loved ones, and work to protect those families. And then, like I said, there was 2 weeks left in session. So we immediately had to think about the long term. And that was, how do we protect and prevent sort of mass devastation to the port operation itself, since it was, shut down at that point overnight. And this is, as you well know, a multi-billion-dollar annual economic engine for the city and the state, and frankly, the country. And then from there, how do you try to, as much as possible, inoculate the prime businesses in the port, and then all of the secondary individuals whose livelihoods would be impacted, the folks who work at the port, and then the more indirect stuff, the businesses and the restaurants that are, facing and around the port and the harbor, and how they're going to be impacted. And so really, for the final few weeks of session, that was our sole focus, was, what can we do to set up a situation in which we could try to protect the economic interests of the port and those most directly impacted. I mean, the reality is that, it's now April of 2025, and we are still trying to get back to pre-Key Bridge levels, whether it's roll-on, roll-off cargo, whether it's the mass stuff that comes through the port, all of these categories. We are still striving, the cruise ships that come through the port, we're still striving to get back to, pre-collapse levels. There's been some immense, significant recovery and improvement, but the financial impact is long-term and catastrophic. For now, at least when it comes to the direct cost of rebuilding the bridge, we are still, in the understanding, and I believe this is pretty firm at this point, that the feds are going to pay 100% for the rebuilding of the bridge. So that's a huge, huge deal for us, because, had we had to come out of pocket for that, putting aside the legal cases and things like that, that would have been just another devastating blow to the state and to the city at a time where we could at least handle it. The other thing, that's been so significant is even just the traffic, right? This major artery that flows over the port, from my district to the 6th legislative district on the east side, is inoperable, of course, until it's rebuilt. And so then you have all these other bridges that are being heavily used by vehicle traffic, and the impact on the economy up to that, right? Simply of people sitting in traffic, unable to get to work and home on time, is immense too. So I think there's the direct cost and impact to the port that we'll ultimately be able to fully calculate. And then there's all the incredible indirect impacts that I don't know that we'll ever be able to fully put a number on.
The man charged with making the decision is Maryland Judge James Bredar, who has set June 2026 as the date for a hearing. The expectation is that Bredar will reach a decision on the main issue of whether the limitation holds or not relatively quickly, perhaps within weeks. After that, it gets harder for European listeners to follow. As American lawyers repeatedly point out, and as anyone who watches Hollywood courtroom dramas knows anyway, the US legal system operates very differently from its English or continental European counterparts. The first question we asked Jana and Jim was to set out the relevant legal framework. They do things rather differently in the US, preferring domestic legislation to the 1976 Convention on Liability, which applies in 50 other countries. So here's first Jana and then Jim.
I will confess that I am not an expert in the international convention, but my understanding is that the two main differences have to do with the limitation caps, and that the international convention has been updated, I think, more often to reflect kind of present day values. So it's considerably, the limitation caps are considerably higher under the international convention, whereas ours is, the value of the vessel plus pending freight. So it's can be much, much lower. And then I believe that the other real difference is that the International Convention is much more strict about can be what can be used to bust limitation, whereas in the US it's based on case law. Our judges, as time has gone on, increasingly don't like limitation, so it's much harder to maintain it in a US court than it is internationally. Um, you know, within the context of the International Convention, I believe that you have to show willfulness and intent or recklessness on the part of the ship owner, whereas in the U.S. it's privity and knowledge, and it can be imputed from a larger universe of people, and it's much more subject to the discretion of the fact finder. So as I say, I think it's harder to maintain limitation under our system.
Well, there's three main differences. One is the limitation fund, two is the burden of proof, and three is the discovery, the amount of discovery that's permitted.
That's James Mercante.
So to go over that, in the United States, the fund, the limitation fund, is the post-casualty value of the vessel. So, for example, when the Titanic, they filed limitation of liability in New York, and they were attempting to limit their liability to the post-casualty value of the Titanic. Well, what was that? It was, most people think zero, but there was the remaining lifeboats. And the post-casualty value of the Titanic was, back then, maybe $19,000 for the value of the lifeboats. The Dali did the same thing. So the limitation is very limited to post-casualty value, where under the London Convention, the 76 Convention, it's the gross a dollar amount by gross registered tonnage. So if, in fact, the Titanic went to the United States Supreme Court, and the United States Supreme Court said that the Titanic owners, even though they were foreign ship owners, they had the same benefit and the same right to file a limitation of liability action under U.S. law that any U.S. carrier had. And once the Supreme Court said that, in entitling the White Star Line to file limitation of liability, all the claimants dropped their claims here, and they went and filed in London against the White Star Line. So there was no claims resolved here involving the Titanic, and that shows you the extreme difference in the two concepts, the U.S. Limitation Act versus the U.K. The other thing is so it's not only the limitation fund, but it's the discovery. In London, for example, there's very limited amount of discovery in a limitation action. Here, there's depositions of witnesses under oath. For example, in the Dali, they've already deposed 10 witnesses, including the crew and the ship pilot, and these are grillings for 7 hours. You're entitled to 7 hours per witness, and every party to the action gets time to cross-examine the witnesses. Where under the 76 Convention, the discovery is really done by statements, affidavits of witnesses, and then a trial. If the judge doesn't uphold limitation and there's a trial, the cross-examination of the witnesses occur at trial. And the other thing, the last point is the burden of proof, which I said, David. It seems to be much more difficult to break limitation under the 76 Convention with the intent or reckless disregard standard, whereas here, under the U.S. law, it's just whether the ship owners ashore, had privity or knowledge of the cause or the contributing factors to the casualty. And that's all it is. It's not reckless disregard. It's not intent like the 76 Convention. It's just whether the owners had knowledge or privity of the issues that caused the casualty. So here in the context of the Dali, there was some extreme vibrations in the engine room that the NTSB was reporting about, and loose wires that caused the breakers to trip and then the ship to lose power. If that information was passed on to the owners, through correspondence or emails, and all that has been, exchanged in discovery, there's been hundreds of thousands of documents produced, then that would be something that could potentially stick on the owners. But nobody really knows the status of that, David, because the judge has issued a confidentiality order in this case. So it's almost like a gag order. So the attorneys are not speaking about the case. The documents are marked confidential. The testimony is marked confidential. So it's not going to be till trial that we'll get to see what's really going on in the case.
We should just mention here the matter of legal philosophy. Some US judges, generally those of more conservative bent, base their rulings on the exact wording of the law as it stands. Others, usually those with more liberal leanings, attempt to interpret what the legislators would have said if they were drafting similar legislation today. In terms of jurisprudence, both approaches are permissible. As far as anyone can work out, Judge Bridar is a mild liberal, but he is not an overtly political animal, so there is little point in second-guessing which way he will go. Then there is the question of how high the awards will be if Bridar does not uphold limitation. In short, this is no limits poker, it seems. Likely compensation claims for loss of life, a replacement bridge, the forced closure of the port of Baltimore, the interruption to businesses in the city, and much else could be off the charts.
It could be huge, yes, and I think that's the $1 million question.
That's Jana Byron.
The answer is no. There really isn't a limit on what can be claimed, and the total value of the case is going to be determined by the value of each individual claim, and there isn't a cap on the personal injury claims. Those are going to be whatever the judge decides, or whatever the fact finder decides those claims are worth. So yeah, each individual death claim could be millions of dollars depending on how each claim plays out. The one caveat I would make is that there is case law in the US that says that if you want to make a claim for damages and for damage to your business, for lost revenue and things like that, you have to be able to show physical damage to your property. So a lot of the businesses, let's say around the port, who have lost business because the port was closed and but didn't experience actual physical damage to something that they own, they may well be barred from recovering based on some existing legal precedent. That's what I personally think is going to be kind of interesting about how this plays out, is how strictly that precedent is applied to these facts, because this kind of stuff, if you're a layperson, seems just unbelievably unfair under the circumstances.
Unless the judge just determines that the ship owners are entitled to limit their liability, that would be the only basis for there to be a cap in damages, because that's the purpose of the Limitation Act, to cap the damages. If the judge decides that the ship owner is not entitled to limit liability, and then it's full on, pretty much full exposure to whatever damages are proved. The damages would have to be proved at trial and subject to whatever defenses the ship owner has.
As Jim made clear in a presentation to the International Union of Marine Insurance conference in Berlin last September, the bridge was getting on for 50 years old and seems to have been poorly maintained. That means that the public authorities should bear a share of the costs. It also means that should their case prevail, they cannot sting the owners and insurers for a better bridge than the one that got knocked down.
I'm quite certain that the bridge, the Maryland Department of Transportation, will share in the fault for this casualty. And it's difficult for people to grasp that concept, because you have a stationary object that was hit by a moving object. And in admiralty law, there's a presumption of fault. When the moving vessel strikes a stationary object, the moving vessel is presumed to be at fault, but it's only a presumption. There can be evidence to rebut that presumption. So the NTSB recently, in March, 1 month ago, came out with a report that was rather damaging for the owners of the bridge, in that it found that they failed to follow some guidelines in evaluating the bridge protection system. And as a result, I mean, they basically concluded, and I'll give you a quick final comment by the NTSB in its March 18th, 2025 report, which is pretty damaging for the bridge. It says, David, the first finding: had the Maryland Transportation Authority conducted a vulnerability assessment of the Key Bridge based on recent vessel traffic as recommended by the 1991 and 2009 Association of State Highway and Transportation Officials, the MDTA would have been aware that this critical and essential bridge was above the threshold of risk for catastrophic collapse from a vessel collision when the Dali collision occurred. So a couple of things that are into play there. The NTSB report in and of itself under maritime law or any law is not admissible in evidence, but it does provide a roadmap to the vessel owners here, because it identifies these studies and will provide a roadmap for the vessel owner to put up evidence of the fault of the bridge owners. And in our system of justice, we have a comparative fault system of justice, which means that there'll be an allocation of fault as between the owners, the ship and the bridge. There should be some reduction in the bridge's damages for depreciation, some reduction for betterment, because obviously going to be made of a different material now, much a more improved construction. It may be elevated higher to accommodate, taller ships. There may be more toll lanes. So whatever they make, when they make this better bridge, they're not entitled to recover 100%. There should be a reduction for betterment. There should be a reduction for depreciation. You have a 1976 black and white TV with a rabbit ears antenna, and someone smashes it, and now you go get a 90-inch flat screen TV with all the bells and whistles. Well, you can't recover the cost of that. So that's where depreciation comes in, betterment comes in as a reduction to damages.
And still more complications. Whichever way Bredar finds, the other side is almost guaranteed to contest his decision. Indeed, the fight could go all the way up the US legal system. We asked Jana and Jim to map out the process. Meanwhile, Mark confirmed that an appeal is indeed being considered.
So the first thing I do want to say about that is that it is not unusual at all to have vessel owners file limitation actions very quickly. In fact, there is a time limitation from once you become aware that a claim could be made as a result of that arises out of a casualty. You have a limited amount of time, and I want to say it's 6 months from the date that you become aware of that claim in order to file a limitation action. And typically, when you've got a situation like this, you use the casualty date as the date that starts that 6-month clock running. I do think that sometimes ship owners get a little bit of a bad rap when they file limitation, because the perception of the Limitation Act is that it seems kind of inherently unfair. And then when you have a ship owner filing it very soon after a casualty happens, I think it leaves a little bit of a bad taste in people's mouths. But from my perspective, at least, all it really is doing is the ship owner is utilizing a protection that is available to them and that they are legally entitled to use. So, I try to encourage people to look at that with a little bit less of a jaundiced eye. The next steps are going to be that the judge has ordered a bifurcated proceeding, and the first, or not bifurcated, but he's going to try the case in stages, and the first stage is going to be deciding whether or not the ship owners and managers are entitled to limit. So they're going to look at fact discovery, which would mean, interviewing all of the crew, predominantly all of the crew, any probably some of the salvage efforts I would imagine would be in there as well, experts on navigation, things like that, and to decide whether or not there was negligence or unseaworthiness, and then whether or not the owners had privity and knowledge, and whether or not the owners have a right to limit. So that's going to be phase one, and I expect it will be fact intensive, lots and lots of paper discovery and depositions. And then in June of 26, there will be a trial on liability.
Judge Bradar, who's running a pretty tight ship, has broken the case down into phases. So phase one, which is underway now, is just discovery related to whether or not the ship owner can be exonerated or be limited in its liability. So all discovery now is streamlined and tightly focused in the owner's defense of limitation of liability. And the trial that you just mentioned in June of 2026, that trial will just be to determine whether or not the vessel owner is entitled to exoneration or limitation of liability. And then it would move on to an appeal, and then on to the damages phase of the claimant's respective damages.
Well, as a lawyer, I'm always advising my client to appeal when we lose if I think there's a good basis to overturn the decision on appeal. And given the size and scale of this matter, I suspect that if the state believes there are grounds to have the opinion overturned, very high likely that it would be appealed. But there is always an intense calculation that goes into the decision of whether or not to file an appeal. I think it probably would be, a lot of it would be based on the substance of Judge Bradar's opinion and how that opinion is drafted, and whether or not there is language in that opinion that would give rise to grounds for a successful appeal.
US litigation has a reputation for being both hugely costly and protracted, and it has to be said, not undeservedly. The lawyers on both sides will pocket millions. One possible precedent is the legal action over the Athos 1, which spilled oil in the Delaware River in 2004. The matter was only settled by the Supreme Court 16 years later. We are unfortunately faced with a real prospect of a repeat performance.
Well, like I said, in the Staten Island Ferry marine casualty, it only took a year. And I say only because that's not a long time for these major marine casualties. As you know, the Exxon Valdez casualty took 20 years before the final decision was rendered by the Supreme Court. The Athos 1 tanker oil spill and grounding took 18, 19 years. I think this Judge Bradar is committed not to draw this out, and by his, hard-knuckled approach to this case, he's come out with 5 case management orders already, and he's really maintaining tight grip on the calendar. So I don't think this is going to take more. I think it's going to be less than 10 years. If you look at it this way, it's already been a year. The trial doesn't take place for another year, right? That's 2 years. The appeal is going to take a year. That's 3 years. And then you're going to have all your damages, and there's going to be appeals of the damages because, only certain parties are entitled to, loss of use damages, that sustained physical damage. So, right there, you're going to have another couple of years tacked on. So I think you're looking at, at least six years.
The judge in the Dali case has set a tight schedule, and all indications are that he's going to hold everybody to that. But I think also that these kinds of cases, when you have a large number of parties and something that is a very visible case, sometimes they can just also take on a life of their own. And litigation in the US takes a really long time, even in non-complicated situations. So, so yeah, I would not be surprised at all if I'm retired before this case is finally decided.
Finally, the political climate in the US is somewhat fraught right now, at least as most Europeans see it. That means that there will be political fallout. Indeed, 2 congressmen have tabled a bill calling for the limitation cap for foreign flag vessels to be 10 times higher than the current cap. If carried, that stipulation would be retrospective from, yes, you've guessed it, March 2024. However, the bill does not look destined to win sufficient support. But we asked Jana and Jim for their take on how this is going to play out politically.
I suspect, given the current environment, I think politics is always in play these days. You've got some different Congress people already talking about changing the Limitation Act retroactively to raise the limit because he thinks that the people of this congressman thinks that or senator, I believe it is actually, or maybe anyway, thinks that this is unfair to the state of Maryland. And I do have some sympathy to that view because, there are many, many people who were minding their own business and their lives were turned upside down by the situation. But at the same time, we have this case law and we have the Limitation Act is there for a reason. So, I think my hope is that people are thoughtful about the decisions that they make about this as opposed to reactive. And I think the current political climate in the United States right now is quite reactive.
Yeah, that's a good question. I don't think you'll see political intervention or pressure on the federal judge because the federal judge is going to base his decision on the evidence and I imagine he'll write an opinion that will be basically appeal proof. And the way federal judges do that is they base a lot of their opinion on the credibility of witnesses. So appeals courts don't like to disturb the trial court's findings where the judge has actually heard the witnesses testify, assessed their credibility, and made credibility findings. An appeals court can't make credibility findings. And that's how federal judges write appeal-proof decisions. And I think that, Judge Bradar obviously is going to limit his decision to the evidence, not politics. And the standard of appeal, the burden of proof on appeal, is if the trial judge findings were clearly erroneous. And that's a very difficult standard to overcome, whether his findings were clearly erroneous. Appeals courts don't like to disturb a trial judge's findings.
And that's it for this episode. Our thanks to Jana, Jim and Mark for their contributions. And in case you're still wondering about the irresistible force paradox, it is what philosophy undergraduates are taught to call an inconsistent formal theory. From the standpoint of classical logic, it's simply a contradiction. As the good citizens of Baltimore now know, an unstoppable force and an immovable object cannot exist in the same universe. Thank you so much for listening. We'll speak to you again next week.